to moderate this special session on ethics in the Indian legal system, which today coincides with the Constitution Day, that is 26th of November. It's a very special day in the life of a lawyer, and the day on which the Constitution came into being. So it gives me immense pleasure to be in conversation with Justice R.C. Chavan, retired judge of the Bombay High Court. Justice Chavan, though retired, is still very much a part of the legal fraternity, and I say, is still, he is tirelessly writing books, delivering lectures, heading committees, and also was a part of the making of the Maharashtra National Law University in one way or the other, amongst his other activities. He is known for his bold opinions, we'll come to that, and is never the one to shy away from a debate. Today I am here to pick his brain on the ethics in the Indian legal system. He has dealt with a lot of ethical issues prevalent today in his book, which is very cleverly titled, Yes, My Lord, It's You in the Mirror. Before we delve into this discussion, I'll briefly introduce his book. I'm sure many of the students of law must have read it. It was released very, very recently. I'll just briefly introduce this book for the august audience present here. The book follows the story of four friends, Azad, Vijay, Narayan and Raju. Let me know how many of you have read this book. And it's a very interesting read, and it will give a lot of nutrition and food to our brain to think about it in the contemporary times. So as I was saying, this book, it follows the story of four friends, four characters, protagonists, Azad, Vijay, Narayan and Raju, from their law school days to their appointment as judges. It takes the reader through their adventures and misadventures. Pausing here, misadventures also, which often include conflicts with the legal system and how each character dealt with an ethical conundrum. The book lifts the mystery of the legal system for the ordinary man and introduces various shades of the profession, both dark and light, just as Chavan has portrayed it as a fiction. It's our privilege today to be a part of the book launch of his new work, which is titled Who Killed the Rule of Law. I'm sure he'll be in our conversation, he'll give us an insight or a little trailer of what the book has to offer to the readers. Now, let's now turn to Justice Chavan, and I'm not going to lose this privilege to, question him, because they keep on questioning us from the bench all the time, and so today I'm really honored to question him today. So sir, coming to your book, Yes, My Lord, It's You in the Mirror. So my question to you is, what compelled you to write this book, and why now?
First part is what compelled me to write this book. Unfortunately in India, there is little writing about the life of judges. There are autobiographies, no doubt. They tell stories. There are law books which contain law reports. But there is little which opens up what happens behind the dais. Okay, you see judges on the dais. What happens behind the dais you never come to know. Therefore, I felt that this was required so that people know how things work out. And I'm glad that after this book came out, or around the time it came out, many other authors also came out with stories examining the performance of judiciary as such. We trust courts, so therefore we must know how far we can believe that courts will deliver justice to all of us. Therefore I wrote that.
Thank you so much.
Why now? She asked,
yes.
Why now? Why now? In fact, it was to be released 3 years earlier. when a friend of mine died. He did not make it to the High Court. He was a judge. Because of the judicial politics, though he was an excellent officer, he could never make it to the High Court. Victimized. And then when he died, he had told his wife and the daughter that his body should be donated, etc. And that is when he died, I felt that injustice done to such persons must be recorded somewhere. I wrote it more than 3 years ago. In fact, it was ready for being printed then itself. But then some turn of events, I had to go to Delhi to be vice chairman of the E-Committee of Supreme Court. And everybody felt that while in office, you should not be committing such an indiscretion. Therefore, I waited till I came back to Nagpur and then released that.
Thank you so much, sir, for that. We all know that there is Advocates Act 1961 and the rules framed thereunder, whereby the regulating authority, that is the Bar Council of India, has framed rules for the professional conduct of the lawyers. To regulate the professional conduct, they have delineated certain conduct as professional conduct which needs to be observed by the lawyers while they are litigating or while they are into this profession. Now, there are certain things which are beyond these rules, and these need to be followed for a lawyer to be, recognized as a good lawyer with a good professional conduct. So, sir, my question to you is that this book of yours, it speaks about the ethical conundrums faced by lawyers. So, would you mind elaborating on these ethical issues for our audience? That is, how should a lawyer balance his duties towards the court and towards the client as well?
I am happy that I am speaking today to all of you on this subject in presence of my very old friend, right from the science college days. He is present in the audience with Bhabiji today, who has seen me all these days, and therefore, if I commit some mistake or make a misstatement, he is bound to bounce upon me. So therefore, I have to be careful. So, thank you, Digit, for being here. See, the ethical conundrum which lawyers or judges face is because of split in the duties which they are supposed to perform. First is duty towards the clients. Of course, you have to survive in life. Therefore, you have to have clients, and therefore you have to be successful. But then, basically, advocacy is all about assisting the court to unfold the truth, to reach justice. That is the basic role of lawyers. It does not mean that when a client comes to you and tells you that he has committed a murder, handing over to police. No. Unfolding his case, unfolding all the shades of his case before the judge is required, because the judge also should be able to come to some right conclusions. Today what happens is, people are after visible success. That is, whether you have a Mercedes or a Skoda or something like that in first few years of practice. That is not real success. Secondly, say by fixing matches, you don't increase your caliber, no. You become a good batsman only if you are a good batsman. Therefore, if you measure success in terms of money or what glitters, you are bound to fail in long run. So, for achieving success, what is required is tough cases, and in tough cases, reaching out to justice. It's not simple. It's a very difficult task to find out what is the right thing to do. is the right thing to do is extremely difficult. Finding out truth is more difficult. Because we are not machines, no? That go in trance, close your eyes and find out what happened at that point of time. So finding out truth from the words of witnesses who appear before the court and assisting the court to reach that truth is what a lawyer is supposed to do. At the same time, you have to be in the saddle. You can't fall off the horse. If you fall off the horse, you are out of practice now. So therefore, balancing these two things, it's not impossible, it's doable. Therefore, this ethical conundrum or the dichotomy can be balanced well if you first understand that your first duty is to ensure that justice is done and that you are supposed to be assisting the court in doing justice. How many of you are studying students of criminal law? Great. Any teachers of criminal law? So, Ankush Maruti Shinde, heard of this case? 6 persons were charge sheeted for gang rapes and murder in Nasik district. They were all ordered to be hanged by the session judge. In the High Court, in confirmation case, 3 were ordered to be hanged and 3 were sent to life imprisonment. In the Supreme Court, all 6 were ordered to be hanged. Only to be found by the Supreme Court after a few years that these persons were innocent. Not just not guilty. They were innocents who had been charge sheeted, and so they were staring at the news for almost 10 years of their life. This happened because judges fail, no doubt. But lawyers also fail, no? They did not unfold all the aspects of the case before the judge. Now judges, she will agree, yes, judges say that it was not shown to us. If something was not shown to us, our eyes are closed, no? Blindfolded goddess of justice. So you have to open the eye of the judge, make him see. There is a difference between hearing and listening. Judges give a hearing. To make the judge listen is an art, isn't it? So learn that in the years that you are going to pass or spend in the law colleges or under the tutelage of seniors. Have I answered your question?
Yes, yes, of course, sir, and I completely agree with that, being a practicing lawyer. And there are cases, in fact, sir has discussed and shared his experience in actual trial matter. But there are instances where in the writ jurisdiction, when the Honorable High Court is hearing out a matter, then the suppression of material facts by a lawyer not just discredits his reputation in the eyes of the court, but that also affects the client very badly, because on this ground itself, sir would have passed so many judgments on that, that for suppression of facts, if an order is secured after suppressing certain facts, that such an order is a nullity. It's a fraud played upon the court. So these are the various ethics which sir wants us all to know, that being successful will not mean that you have to adopt and follow unethical ways. This is especially for the students of law, that don't just look at the Mercedes and the BMWs that the lawyers ride, you know. It takes a lot of hard work to achieve that. Alright, so continuing with the protagonist in your book, and in continuation of what you said is, you have said that ethical ways need to be adopted and it's indispensable. Now, one of the character in this book, Vijay, you have shown him as an honest lawyer who tries following ethical ways to secure justice to his clients, despite facing many ethical challenges or various challenges. Now, how does Vijay's formidable moral character, sir, it contributes to the moral of the soul?
See, basically, we start believing that the world is wicked and saints have really no place in this world. We are told that what is there, the Chief Justice of India says, former Chief Justice of India and now an Honorable Member of Parliament said after retirement, that judges don't fall from heaven, and so do lawyers also don't fall from heaven. And therefore, we are trying to be convinced that ethical ways don't pay. Vijay is an example where ethical ways did pay. He had struggles, but those struggles did not deter him from wavering from his path. See, it's easy to slide down a mountain. It's easy to flow in a stream. It's difficult to climb up. The choice is yours, whether you want to climb up or slide down. If you want to slide down, nobody stops you. It's very easy. The fall is precipitate. So therefore, ethical ways to pay. I have come across many very good lawyers who had a lot of troubles in their practice, but all the same, they were the ones to whom clients and even senior advocates would go when they are in difficulty. Because these people fought their battles by their skills, by their knowledge, by their experience. Whereas those fixers who jumped the queues, they can't withstand the pressures when it is a really tough case. So therefore, for tough cases, even these people go to those lawyers. That please help us. I don't know. If you cultivate the habit of reading from the beginning, analyzing things from the beginning, then you will know something of law. I know only little of law after so many 50 years now. Okay. So therefore, it takes a lot of time, a lot of trouble. But then devote your life, because the satisfaction which you get after ensuring that justice is done to maybe your client or opponent's client, when you ensure that justice is done, that satisfaction is great. And we work for that satisfaction. That is success. Not getting a fat fees. It doesn't matter.
I think better. This will not much appeal to the students of law. They will say that fat fees plus success, both. Okay.
Ma'am, see, both the things are possible. But for that, you have to learn many tricks of the trade.
Yes.
Okay. It's not necessary that you should become a sannyasi. Athartha Brahma Jignasa is not required. You don't have to go to forest for meditation. You can be here. Many of you may be from Maharashtra. Sant Eknath was a man of worldly ways, but he was still sane. So therefore, finding out how to survive, how to make a living, how to make a successful living, and at the same time, not giving up your passion for justice, passion for truth is possible, 100% possible.
Sir, thank you so much for that. Sir, as per a report which was published in a reputed newspaper, almost 93% of the candidates who appeared for the examination of advocates on record, they failed in this subject, professional ethics. So, my question to you is that, is this in any way an indication of the decreasing significance or decreasing importance of professional ethics, sir?
I have a question.
Yes.
Just take a lighter question.
Yes.
When you said reputed newspaper, you were talking about the past or the present?
So what I be saying that it's a recent.
Sorry for that.
So sir, that's my question, whether that indicates a decrease in the importance of or a significance of the professional ethics. Because how can it be that, because advocates on record are already lawyers, they have already been through that subject of professional ethics, and a 93% failure, what does it speak?
If the audience is not going to beat me just now, I hope tomatoes and eggs are not permitted. I'll tell you one thing. How many of you have ridden two-wheelers without helmets? Nobody is going to punish you here. You can raise your hands. many of you have broken the signal?
Those raising hands and not the others also.
See, the unfortunate part is this, that we obey law only when there is a constable around. There is somebody watching us. And this is inculcated since the beginning. And this is what translates into practice when you come to the court. There was a great judge from Nagpur, Justice C.S. Chandrasekhar Dharmadikari. He used to say that ordinary people break ordinary law like a traffic signal. Big people break big laws. And big lawyers break big ethical practices, ethical rules. Unfortunately, the Bar Council of India and the Bar Council of Maharashtra and Goa are quite indulgent. They are quite kind-hearted. So that's the same thing about medical profession as well, or chartered accountants also. It's not that our standards of judging people have gone down. That is the trouble. So therefore, you have to raise yourself. You have to distinguish yourself. And I again assure you that you won't lose money by being ethical. Being ethical is good. Mahatma Gandhi was not a fool, no, for teaching sadhana shuchita, isn't it? So means are important. So go by that advice, and then you reach not only riches but also a good day. Adama dhanamichanti dhanamanavati madhyama. Uttama manamichanti manvahi mahatam. What you need is respect. No? You may be a very big man, but not respected. What is the point? Holding a big position, but people behind your back say, "Oh, such a dirty fellow," isn't it? So, therefore, and when you fall from the top, your bottom is bound to be hurt. So therefore, take care of your bottom and don't fall from the top. When you reach the top, it should be, your feet should be firmly at that place.
Yes. So, these days we often see in the newspapers, one full page is dedicated to reports on public interest litigations. So, what do you, and in a lighter way, they are also known as publicity interest litigations these days. So, what do you think is the cause for spate in such litigations?
Everybody likes recognition. Everybody wants recognition. Everybody wants to be seen in newspapers or media. And therefore, people love this publicity interest litigation. It is unfortunate that the Chief Justice of India had to recently, ma'am, you can ring the bell, don't worry.
Lawyers and judges are both, used to giving talks.
No, you can ring the bell. So, the Chief Justice of India recently said, he dusted out 250 references to 7 and 9 judge benches, which are pending for more than 10 years. Why? Because the Supreme Court was taking up matters which came up, which hogged publicity, isn't it? May not be PILs as such, but which gave them headlines in the newspapers. Was it not their duty? Why this dusting of 250, not 1 or 2? 250, and this is not what I say. The Chief Justice of India says. Publicly. So, and on these 7 and 9 bench references, hundreds of other matters may be pending in the Supreme Court itself. Because the matter is referred to 7-judge bench, so that the bench settles the law, matter comes back to the regular bench of the Supreme Court, it then decides the matter. On these decisions, thousands of matters may be pending in high courts and lakhs in trial courts. Who is responsible for this? You are taking up cases which are insignificant. Long ago, a report was published in which, by names of judges, that how many judgments they delivered in which some constitutional issue was involved. This was about the Supreme Court of India itself. And it was found that in most of the cases there was no constitutional issue involved in the cases. So if you waste your time like this, lawyers are bound to take you on the right note. They also want that. So therefore, publicity interested litigation or public interest litigation should be restricted to a great extent. And in fact, if it is necessary for ensuring that justice is done to a person who is not able to represent himself, or a class which is not able to represent himself or herself that class, then we should be giving legal aid. No. Get it come in the regular course, no issue. But then all of you want to distinguish yourselves, no? Isn't it? So judges also are distinguished judges. They want to distinguish themselves.
Thank you so much, sir, for that. So the take in this is that if the issue is not so important or it doesn't carry a public importance, the lawyers should desist from taking up such issues for two reasons. Firstly, because it would waste a judicial time, and such time could be used for deciding other important matters of the other litigants. So the lawyers owe a duty not just to the public by saving the judicial time, but also to the other litigants. So this is what I feel is the students of law can take away from this answer. So now coming to you have been very vocal about the idea of an ideal judge in this book. Yes, my lord. So, sir, can you just elaborate briefly on this idea in the context of administration of justice?
Professor Venkatraman is fortunately here, and I had sent to him the question papers of recruitment tests for judiciary, and he had a very bitter comment to make, which was forwarded to the authorities. See, right from the beginning, right from the way we recruit people. Now for Agniveers also they are going to have a psychometric test. Today's newspaper carries that news. What about judges? All the high courts have candidly replied to me in official capacity. When I was sitting as Vice Chairman of the E-Committee of Supreme Court, made a query about the recruitment tests. And I asked them, is there anything in your tests to find out whether a person has a sense of justice? They said no, that is out of syllabus. So, this is the tragedy. Forget this. What I suggest to you as lawyers is this. It's a question of your future. Tell me frankly, how many of you are going to report to a policeman or go to a court if there is some infraction of law in respect of yourself? Say your mobile is lost, or somebody snatches your wallet. We are afraid of law. We are afraid of law, that is policemen. We are afraid of courts. We are weary of going to courts, isn't it? This is again not what I say. Quoted in this book, what Justice Ravindranath of the Supreme Court says. I've taken this care because people should not bash me for saying things. Justice Ravindranath, in an official journal of the National Judicial Academy, way back in 2015 said this, that people don't come to courts now, they don't have faith in courts. For you it is an important question of your survival, your future. If you are going to be in the law, you have to ensure that courts work efficiently. You have to ensure that the courts deliver justice in time. This alone will ensure that you get more work. Now, ma'am, please, how much time?
5 minutes. So
5 minutes.
what I'll do is, I'll just give just one question.
One answer to this. What we are doing today, we are advertising. Don't come to courts. Don't come to courts. We don't do justice. When you come to us, we send you to Lok Adalat, arbitration, this and that. If you publicize that coming to courts is useless, then what is the point in wearing a black coat and joining a law course? What is the future for you? If you want to ensure your future, this system has to work efficiently. And you have to make it work. Thank you.
The last question, it's a important question. Please give me an opportunity to ask you that with the kind permission of so just one question, then we can just have a question and answer session. So, because actually I am giving up on other questions. I was very much interested in the inquiry.
But you can bring me later.
Later. So, judges are addressed as your lordships or my lord in the courts. A lot of judges are criticizing this practice and often requesting advocates to use the more colloquial sir or ma'am. You all must have read in the newspapers or in the live law, they have already stated. Even Justice recently, Justice P.S. Narasimha of the Supreme Court said that if you continue to address me as lordship or my lord, I shall give half of my salary to you, is what he said. Even the Rajasthan High Court, in its full court meeting, sir, in 2019, unanimously passed a resolution instructing the lawyers appearing before judges not to use lordship or my lord. It stated that this was to honor the mandate of equality enshrined in the Constitution. My question is, sir, that use of such terms, does it put a judge on a pedestal which is far from trials and the tribulations of the common man?
Now at least some of us start feeling that they are near the heaven when you go on addressing them as my lords, my lords. So apart from this, for lawyers, no, when they are not finding the exact word, they say my lord, what my lord I mean, my lord is, my lord that, because they are groping for words. Therefore, this is going to be difficult to give up that habit. Tell me one thing, in the past, before say Mughals came to India, we had kingdoms now. When a person went to the king's court for seeking justice, how did he address the king?
Your Highness.
Maharaj, no, your Highness came later. Maharaj. So the courtiers said Maharaj, Maharaja Viraj, etc. But when common man went to seek justice from Raja, Raja, माझी बकरी क्या माणसाने चोरली? Raja, Maharaj नव्हे. How are kings addressed by people, common man, when common man went in for seeking justice? Was the king accessible to common man? Yes, ring the bell and go in, no. The king would come out, isn't it? So therefore, this lordism is a relic of British past, and the earlier we give up, the better it would be. It would speed up at least some. It would save time of court.
Yes, and I think that it would also reduce the distance between the bar and the bench, so far as justice dispensation is concerned. And sir would be better for us from my point of view as a lawyer. So lastly, sir, what do you hope that the readers and more particularly the students of law will take away from this book of yours, the last one? Yes, my lord, it's you in the mirror.
See, from Yes, my lord, it's not just a story. There are many stories. So how cases are conducted, how people lose or win, what tricks are played. Everything can be there. It's not just for judges, it's for lawyers also. Lawyers will have a lot of material in it, how to fight cases. Apart from that, this one.
Yes, I was just coming
this
to
one,
that. Yes.
This one contains instances with names. That was a fiction, work of fiction. Okay. But since the work of fiction did not tickle the minds of people who were supposed to take some action, this punch had to be delivered. Okay. This contains names, judgments, actual judges, and how they forget that they are supposed to be doing justice. Therefore, see, for all of you, it's important to ensure that we push for dharma, that not dharma, religion, not Hinduism or Islam, the duty to do justice and duty of lawyers to ensure that they assist in achieving justice. Don't forsake the case of your client, but you unfold all its shades. That is all, whatever he wants to say. But don't attach your ego to that. If you attach your ego to that, then you're bound to fail. So I earnestly request all of you, because I see all youngsters here whose future is in law or who have chosen law as a profession, possibly making their parents pay a fat fees, right? So therefore, if you have chosen this as profession, you must ensure that it works for you, that you have sufficient remunerative work in times to come. And for that, the system has to work efficiently.
Thank you so much, sir, for that, those words of wisdom. Quickly now, I would request the audience to just, we'll take only 2 questions because of the time constraints. So, I would request sir to answer those 2 questions from the audience, please. Yes. Yes, ma'am.
Thank you, ma'am. So, sir touched upon the case of Hon'ble Justice R.C. and said that the accused were not just not guilty, but also innocent. So, it's slightly technical, but I wanted to understand what the difference between not guilty and innocent is. Because I understand a lot of us use it interchangeably. So, it would be nice if you could just throw light upon that.
Sir, a question was formed
Yes.
from a student, right? Suppose you are a student.
I'm working as a corporate law.
I have heard your question. See, not guilty is when the evidence does not pass the muster. Okay? The person may be guilty, but his guilt has not been proved. Okay? The court does not say that he is innocent. But in Ankush Maruti Shinde's case, what had happened is, these 6 innocent persons were caught by police. Why this happens? Whenever there is a gang rape and murder, or something like that, some heinous crime takes place, there is a lot of pressure on the police also, from the political executive, from public. And then police pick up some 5 or 6 persons, send them for trial. Now, after this, it is the duty of the courts, the magistrate at the first instance, to reject that charge sheet, saying that no, this doesn't work. Then the session judge who frames the charge, he has to say that no, this material is not enough to frame charge. He doesn't. Then lawyers also don't argue no. Lawyers don't argue for discharge. Lawyers don't argue for throwing away a charge sheet. Because if the charge sheet is thrown away, their all income is gone in one go. If the case prolongs, they get more time, more money. Then appeals and all that. So not guilty and innocent, there is a vast difference. A person is innocent person is put up for trial, as in Ankush Maruti Shinde. That is not the only case. Ma'am, one more extension of time for me. Okay. You remember Magegaon bomb blast case? It's a serious case affecting the integrity of India. Attack on common man. What happened in Magegaon bomb blast case? First, 6 or 7 persons were sent up for trial. Their confessions have been recorded by high-ranking police officers that yes, we did that. Then they were discharged. And another set of Colonel Purohit and others, they are facing trial now. Sadhvi Prajna Singh and Colonel Purohit. This mockery of justice. How many years have passed? So therefore, I guess all of us are vigilant. Don't just blame the government or the police. They are under pressure to work and they send a charge sheet. But we are supposed to be vigilant. And it's not judge alone who does justice. 2 advocates and the judge. 3 of them. 3 minds have to go in. Honestly. To scrutinize everything. Have I answered you?
Yes.
Or you are not satisfied?
Absolutely correct, sir. Thank you so much for that. With this last piece of wisdom from Justice Chavan, we conclude today's session. I'm extremely sorry that without anything more, we had to drop the second question also, because I can see the problem, here. So, yes, or definitely. So we conclude today's session with profound gratitude to Justice Chavan for sparing his valuable time and enlightening all of us, more particularly the students of law who are present here. And I'm sure they'll carry some great insights into the ethical conduct which is expected of a legal professional. And thank you so much to all of you for being present here and bearing with our questions. Thank you so much.